Hi guys, this is Erica from Gokce Capital.
Now before I begin, be sure to subscribe to our YouTube channel and turn on notifications. Consider this scenario. Say you're looking to buy a property. Your seller informs you that she inherited the property from her father, who passed away a few years ago without leaving a will. She has two brothers, but she claims she is the heir to the property because she has been paying property taxes for the past couple years. When you speak to your title company, they tell you that they will not insure the property because it is not clear that your seller is the sole owner. Given that there is no will and probate was not done, this is a clear example of when quiet title would be needed. Curious how this case turned out? Stick with me through the end because I'll let you know the conclusion after I have covered the top 6 things you should know about quiet title. Now, quiet title is a lawsuit. It's an action lawsuit or legal proceeding that clarifies property ownership and establishes the party's title to a property. Thus, there is a plaintiff and there are defendants. The plaintiff, who's bringing the quiet title action to court, is almost always trying to establish their title to the property. And the defendants would be anyone else who could potentially have a claim. So the first thing you should know is that the whole point of quiet title is to help clarify ownership. And this could be ownership over the whole property or over a portion of it. Well, as our opening story showed, quiet title is often used when a title search reveals that there may potentially be multiple claims to ownership. And this often happens when an owner of property passes away and their assets are not properly conveyed to their heirs. Quiet title may also be necessary if there is an adverse possession claim on the property. If a title searcher's survey indicates that there may be encroachments, boundary disputes, or other survey issues that generate a question over a portion of the property, you may need quiet title. And if there were improper transfers in the chain of title, it may be necessary to initiate a quiet title action if those improper transfers were done far enough back that they cannot be rectified via other means. Number 2, you may need a quiet title action to get a mortgage. Almost all lenders require clear title and title insurance in order to lend for the purposes of purchasing a property. Thus, if there is a discrepancy in the title that would require a quiet title action to clear, then you will need to go through this process in order to obtain title insurance and thus a mortgage. Number 3, a quiet title action can be a lengthy process. The length of time will depend on how complicated the issue is and whether any other parties are going to contest the plaintiff's claim to title. The average length of time is about 2 months for a simple quiet title action, but it can take up to 6 months if the process becomes complicated. Number 4, you should hire a lawyer if you need to go through quiet title. Again, quiet title is a legal procedure, and thus you want to be appropriately represented. What this means, though, is that quiet title is not necessarily cheap. The exact amount your lawyer will charge varies on the specifics of your case, again, how complicated the action is expected to be, and where you are located, but you should budget for at least a couple $1,000s. Number 5, a title company may be able to help you avoid quiet title. Now, in case this video is making you nervous, there are many issues that can come up in a title search that are able to be resolved without quiet title. In fact, the majority of discrepancies in a property's title can be cured for you by your title company or lawyer using less expensive and less lengthy means. For example, we were recently looking to purchase a property in California, and the title search revealed a discrepancy in the chain of title in that one owner's spouse did not sign a deed conveying the property to the next owner, and thus there was a lingering community interest in the land. This issue did not require quiet title. Rather, the title company reached out to these prior owners and had a quitclaim deed recorded whereby the spouse relinquished all potential interest in the property. Number 6, quiet title is also relevant in certain unique purchasing situations. By far the most common scenario where quiet title is required is when a property is purchased through a tax sale. The details vary from state to state, but often a title company will not insure a property that was purchased through a tax sale unless either a certain amount of time has passed or a quiet title action is initiated to erase any interest that the prior owner who lost the property through the tax sale may still have. In a similar vein, properties purchased through foreclosure may require quiet title as well for you to obtain title insurance. In certain situations, if you acquire a property with a quitclaim deed, a quiet title action may be required. This depends on the specifics of your situation. For example, if there was a quitclaim deed because a property was being conveyed from an individual to their trust, this would not be something that would require quiet title. But if a third party quitclaims a property to a new owner, in some instances, a title company may require a quiet title action, depending on what else is going on in the chain of title. So there you have it. Those are the top things you should know about quiet title. But most important of all, be careful. Quiet title does come with risks and limitations, and you are not guaranteed to win your suit. Now, if you go back to our opening example, this was a true story, and in that instance, when the daughter brought a quiet title action to establish her sole ownership over the property, the court did not rule in her favor and decided that the property was jointly owned by her and her two brothers. So you are not guaranteed to walk away from a quiet title action with clear title. This is why it's always important to consult with a lawyer before initiating a quiet title action. Now, if you have any stories about quiet title, please share them with us in the comments. And if you like this video, you're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down properties at gokcecapital.com/listings. Finally, if you have any questions, don't hesitate to reach out. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.